Melania Trump, quote, very involved in Epstein scandal, author. It's that particular patois where they, say a thing and then they attribute it with a colon. Yeah, punctuation is like jokes. It's funnier if you explain it. Anyway, the article implied that Melania and Epstein and Trump and Ghislaine Maxwell all hung out together back in the late 90s. Welcome to Law and Chaos, where the Ninth Circuit wants to let God King Trump flood the streets with soldiers. Trump's insurance lawyer, Lindsey Halligan, is chatty Cathying all over Virginia, and there is gambling at Rick's and in basketball. I am shocked, I tell you. We got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you?
I'm all right. I'm, looking forward to the weekend, but it was a nice week.
Yeah, me too.
All right. Well, we have a packed show today. We will start in Virginia, where Lindsey Halligan is proving exactly why it was a crazy idea to make her a U.S. attorney. Then we will move to New York to talk about the massive gambling indictment unsealed today. Then the Ninth Circuit's ruling in the California National Guard case. And finally, we're going to talk about Trump's demand for $230 million from the U.S. Treasury.
And for subscribers, we are breaking down journalist Michael Wolff's lawsuit against Melania Trump.
All right, let us get this party started in D.C.
If you follow us, we can contact Metro PD and they can come handle you. If that's what you want to do. That's what you want to do.
That was obviously the Imperial Death March from Star Wars being played by a guy named Scott O'Hara, who wanders around D.C. making TikToks of National Guard troops being confronted with the world's most obvious analogy. That analogy appeared to get under the skin of one Ohio Guardsman, Sergeant Devin Beck, who called the D.C. cops on O'Hara. The cops then cuffed and detained O'Hara for more than an hour, and now, with the help of the ACLU, he has filed a 5-count complaint against those D.C. cops and Sergeant Beck for assault, wrongful arrest, and violation of his First Amendment and Fourth Amendment rights.
Oh, Liz, you have to let me read the intro from this lawsuit.
Of course.
The law might have tolerated government conduct of this sort a long time ago in a galaxy far, far away. But in the here and now, the First Amendment bars government officials from shutting down peaceful protests. And the Fourth Amendment, along with the district's prohibition on false arrest, bars groundless seizures.
Yeah, that case has been assigned to Judge Tim Kelly. He's a Trump appointee, but he's more or less reasonable.
These are the droids that you're looking for.
All right, simmer down. Okay, Friday, maybe even as you are listening to this, New York Attorney General Tish James will be arraigned in the Eastern District of Virginia before Judge Jamar Walker. Presumably, Lawfare's Anna Bauer will be in the courtroom to catch up with her BFF, Lindsey Halligan, the unlikely U.S. attorney in that district.
Yeah, in case you have not read Anna's wild story about getting browbeaten over Signal by Lindsey Halligan, who then tried to retroactively make the exchange off the record, we will link to it in the show notes. The U.S. Attorney's Office use of Signal messages, aka ephemeral texts, to reporters has already appeared in a motion to enforce rules prohibiting extrajudicial disclosures.
Oh, you think?
Yeah, right. So Tish James's lawyers noted that it is a crime to violate grand jury secrecy. And oh, by the way, Your Honor, sometimes judges hold lawyers who do it in contempt. They did not specifically ask for anyone in this case to be held in contempt. Instead, they listed all the ways that Lindsey Halligan's leak was totally inappropriate. It violates Rule 6E of the Federal Rules of Criminal Procedure, which requires grand jury secrecy. It violates the corresponding federal regulations. It violates the Eastern District of Virginia's local rules. It violates the American Bar Association's model rules of professional conduct for a prosecutor to speak to the public about a pending case. And it violates the Justice Department manual.
But other than that, it is totally kosher.
Right. So James asked Judge Walker to order the government to knock it off, no more signal messages to anyone about this case, and to turn over a log of all communications between Halligan, her staff, and the media, which seems entirely fair. And, oh boy, tomorrow's hearing should be caliente.
Oh, yeah. And remember how in the Jim Comey case, Halligan had to bring in prosecutors from North Carolina because no one at the Eastern District of Virginia would get near this rancid pile of crap? Well, until yesterday, Halligan, who, again, has never tried a criminal case in her life, was the only attorney entering an appearance on the Tish James case. But she finally found someone willing to be her Sherpa on this doomed expedition. That's a lawyer named Robert A. Keller from the U.S. Attorney's Office in Missouri who entered his appearance yesterday.
Yeah, welcome to the party, counselor. You picked a great time to show up. I was wondering if those goobers from North Carolina that were seconded to the Eastern District of Virginia for the Comey case would be willing to light themselves on fire twice. I guess not. Well, anyway, good luck fielding the discovery motion about your new boss's signal messages, Rob. I would note that Halligan had to go even further geographically to find a lawyer for this one. Unlike North Carolina, Missouri isn't even in the Fourth Circuit, although Keller does seem to have been practicing law for about 3 decades. So, I guess he knows what he's getting himself into.
I mean, does he? Although I suppose he was probably committed before the stuff about Anna Bauer and the signal messages dropped. Anyway, while we're in the Eastern District of Virginia, we have an update on Chatty Cathy's prosecution of James Comey for lying about his conversations with reporters.
It's a trap.
Yeah, simmer down. So on Tuesday's show, we discussed Comey's motion to dismiss because Halligan was unlawfully appointed, which, by the way, Tish James told the court today she will be moving to join in the interest of efficiency because as we've said, these cases have to be heard by an out-of-district judge, which, okay, that makes sense. Judges in the district have a statutory right to name a U.S. attorney when the position is vacant, so they have skin in the game. Plus, they deal with the U.S. Attorney's Office on a daily basis, so it doesn't really make sense for them to adjudicate a motion to disqualify the U.S. attorney, which is why Judge Matthew Brann of the Middle District of Pennsylvania was the one who ruled that Alina Habba couldn't be the U.S. attorney for New Jersey, that she was not legally appointed. New Jersey's judges didn't want to hear that. They'd already expressed their preference that someone else, i.e. an actual prosecutor, be put on the job.
Yeah, here, Virginia is in the Fourth Circuit, so the chief judge of the Fourth Circuit assigned this motion to Judge Cameron McGowan Curry, a senior judge for the District of South Carolina and a Clinton appointee. She will come up to Virginia to hear the motion to disqualify Halligan, but to be clear, the main case is going to stay with Judge Michael Nachmanoff. This special designation is only for the disqualification motion itself.
Yeah, we keep talking about these U.S. attorney appointments, and I know it feels sort of weird and obscure, but we are living in this moment where the executive branch is openly flouting laws. And when they can't find an emergency authorization to justify it, they come into the courts with this kind of one weird trick bullshit. I want to read you this passage out of the government's brief in defense of Bill Essayli, the MAGA loon they stuck in as U.S. attorney for the Central District of California, which is Los Angeles. His appointment expired months ago, but he's still on the job. He went on Glenn Beck's show and said they had some tricks up their sleeve, which is its own thing. So the Justice Department's position is that when Essayli's interim appointment expired after 120 days, Pam Bondi made Essayli his own first assistant, which meant that he got automatically promoted to acting U.S. attorney under a law called the Federal Vacancies Reform Act. Bondi also appointed him as special counsel under the same law that Merrick Garland used to appoint Jack Smith, which sounds crazy, right? Like, how could he have all of these jobs, some of which require Senate confirmation, some of which do not. And you know what? It didn't sound less crazy when the government said it in its brief. This is literally what they told the court. if Mr. Essayli were no longer serving as the acting U.S. attorney under the Federal Vacancies Reform Act, it would not follow that he must be disqualified from participating in the prosecution of these cases, supervising other federal prosecutors, or both. He would still be the first assistant U.S. attorney. The Federal Vacancies Reform Act has nothing to do with the Attorney General's power to appoint special attorneys or designate supervisors. Mr. Essayli is right now wearing 3 hats. 1, a special attorney. 2, the first assistant U.S. attorney of this office. And 3, the acting U.S. attorney for the Central District of California. The first 2 of Mr. Essayli's hats were given to him by order of the Attorney General, and the third by operation of the FVRA. Taking away the FVRA role would not disturb the first 2.
The emperor's new hats. I mean, United States law is not a hidden map on the back of the U.S. Constitution. This is not national treasure, right? The Federal Vacancies Reform Act was passed because Congress was mad that President Clinton and past presidents were circumventing the original Federal Vacancies Act to install officers without Senate confirmation. The Trump administration is just flouting every statute, and when they get hauled into court, they put this utter garbage on the public docket. Yeah, you are an assistant U.S. attorney, and your actual position that you have taken before a real-life judge is that this asshole Essayli is simultaneously the first assistant and the position that he could only ascend to if he was previously the first assistant, and to boot, he's also a special counsel? What is this?
Yeah, no, it's bullshit. So that's why the Third Circuit was so hostile to the same argument on Monday when they heard the DOJ's appeal of the ruling that Haba was illegally appointed, right? Because, as you said, if you say this out loud, if you actually explain it, you sound insane. And that is why we think that the Tish James and James Comey indictments are both in trouble, because Halligan is the only one who signed them. And if Haba wasn't legally appointed, then Halligan definitely wasn't. And so depending on how the Fourth Circuit rules, both of these indictments against Comey and Tish James may well wind up dismissed, which not a bad result. That would be very funny. All right, we're going to take a brief ad break unless you are a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case, not for you, baby. Not today and not ever. And we're back. Today's breaking news is the FBI's arrest of an NBA head coach and more than 30 other people, many of whom are connected to the mafia, for high-stakes illegal gambling. This story involves basketball, sports gambling, and cheating at poker. So I'm going to let you take the lead on this one, Andrew.
Caveat, my dad raised me to be a college basketball fan. We don't have an NBA team here in Baltimore, but I do like to play poker, so buckle up. There were 2 separate indictments that got unsealed today. One has to do with cheating at cards, and the other has to do with cheating at basketball. And the connective tissue underlying both of these indictments is a former basketball player and LeBron James's personal shooting coach, a guy named Damon Jones. And to be clear, everything that we're about to say in this segment comes from the indictments. These are allegations. Criminal defendants, including Jones, including everybody named in this, are innocent until proven guilty. But here's what the government alleges. See, it all starts out with Flappy and his pals H, Screwly, Black Rob, and Seth.
Seth is going down. Like, I don't even know what's about to happen here. But if your co-defendants don't even like you enough to give you a nickname, they are totally going to let you take the fall. That's all I got here. You tell me what actually happened.
Okay, so these guys set up some illegal underground poker games in Manhattan and New York. Right now, look, I don't want to moralize too much on that yet, because technically, if you've ever, say, played poker with your nephew and brother-in-law and that guy you played ball with back in high school in the basement, like, you've participated in an illegal underground poker game.
Is your nephew the starting point guard for the Miami Heat?
Is my nephew Scary Terry Rozier? No, but he is a show listener, so hi, Sean. Anyway,
hi, Sean.
Look, poker is hard. Don't take poker advice from a podcast or anything. but I have it on good authority that poker gets much easier if you know what cards the other players have. According to the documentary Rounders, there are lots of ways to find that out. Discard calls, false shuffles, overhand runoffs.
Now, some people might look down on Worm's mechanics, call it immoral. But as Canada Bill Jones said, it's immoral to let a sucker keep his money.
I don't know if Black Rob knows how to pull off the double duke, but he did know a couple of other guys, Tony, Kurt, and Sugar. And apparently they just brainstormed. They had a session to figure out how to cheat. They had old school marked cards that could only be read with special sunglasses or contacts. They had some of these newer scams where you use a deck that has embedded RFID chips in it and they get read by a device and you could disguise the device as like a chip tray or a fake cell phone. But I guess eventually one of the marks would, like look over and be like, hey, sure seems like you bring your special phone with you to poker night. And why does your special phone look like Zach Morris used to have it in 1993 on Saved by the Bell? And why does it spell Nokia with 2 Qs and a 6? But okay, look.
But not beating that dork allegation.
Right. So here's what they did next. If you're playing in Sean's basement for 50 cents a big blind, you just pass the deck of cards around and each person deals and whatever, it rotates. And you don't invite Edward Norton to show up. But if you're playing for high stakes, somebody might try and cheat. And one of the things that casinos figured out a long time ago is that if you don't let the players touch the cards, it's a lot harder for them to do all that worm stuff from Rounders, right? So casinos pay a dealer to deal out the cards instead. And then to make sure that one of the players doesn't bribe the dealer to cheat, casinos started using a machine to shuffle the cards. So these guys hid their card cheating device inside the shuffling machine that was designed to prevent cheating, which plus several points for creativity.
All right, let's read from the indictment.
Yeah.
The rigged shuffling machines were secretly altered to read the cards in the deck, predict which player at the table had the best poker hand, and relay that information to an offsite operator. The operator then communicated that information by cell phone to a member of the cheating team seated at the table, referred to as the quarterback. The quarterback used secret signaling to share the information with the other members of the cheating teams.
Now, rigged cards and operators and quarterbacks all cost money.
But what about rigged shuffling machines? Question mark.
Foreshadowing. Yeah, but still, my point is, this is an expensive scam, and you're not going to win that back in the basement when Mike goes all in for $19, right? Like, what you need to do is invite some rich suckers over to play. They're called whales, and you bring them in, they lose a lot of money. And this indictment says specifically that the cheaters managed to scam the whales out of more than $7 million. But there's a problem. If you're the kind of rich whale like John Doe number 1 who can lose $1.8 million at poker, you probably do a lot of other fun things on a Friday night in Manhattan, right? You go to a real casino. So there has to be some incentive to go hang out in Flappy's basement instead. And that incentive was, hey, would you like to hang out and play cards with some former professional athletes? The athletes were called face cards, and the cheaters invited at least 2 former NBA pros to be face cards. That is the current head coach of the Portland Trail Blazers, Chauncey Billups, and a former Cleveland player named Damon Jones from the Cleveland Cavaliers, and we talked about him in the introduction. The government says that the cheaters agreed to give a portion of their winnings to the face cards, which would strongly imply that the NBA guys were in on the scam.
But scamming people out of millions of dollars is kind of risky. And on top of which, you need someone to launder the money. And you probably need muscle to protect these games when people are wandering around with all of that cash.
Yeah, but they got that covered too, because as it turns out, Flappy knew some guys in the mafia. Specifically, the Gambino crime family. And the Gambinos brought in the Bonanos and the Genoveses. And the mafia, as it turns out, is pretty good at money laundering and leg breaking.
Okay, we're going to take a quick ad break, and then we will come back and find out how this brain genius operation came crashing down and turned into a criminal indictment.
And we're back. And now we can put together all the pieces of the puzzle for this first indictment. It is 7 conspiracy counts, 1 for wire fraud because the operator of the card counting device that was hidden in the little shuffler used a cell phone. There are 2 counts of operating an illegal gambling business with more than $2,000 in revenue, 1 count of money laundering, and then 3 counts under the Hobbs Act for extortion and robbery. And by the way, that robbery count comes from the fact that the cheaters allegedly didn't pay for one of the rigged shuffling machines. Instead, they had the muscle, I love these names, Big Bruce, real name Osman, and a guy named John South hold up the guy who was either making or supplying these rigged machines at gunpoint so that they could steal it.
Yeah. Just like as a side note, we often say it's not RICO, it's never RICO when we're talking about the threats to use the Racketeering, Influence, Corrupt Organizations Act to bring conspiracy charges. And this really does sound like RICO. Like if there was ever a case for RICO, you'd think it was this one. The Justice Department alleges a conspiracy to commit illegal gambling and money laundering, and those are RICO predicate offenses. They allege the conspiracies with the mafia, which is definitely a racketeer, influence, corrupt organization. But because this is a real case brought by real prosecutors who have been investigating since 2019, it's not RICO because RICO is a pain in the ass and it doesn't really get you that much more, right? Like if it made sense to charge it as RICO, they would have.
Right.
And just for comparison, a couple of months ago, we wrote about Trump threatening to bring RICO charges against Code Pink protesters for chanting at him for 45 seconds before he ate dinner at, I think it was Joe Stone Crabs.
Yep.
The Justice Department, and this really illustrates how ridiculous and thuggish that threat was, right? Here we have the DOJ will not bring a racketeering statute against actual racketeers, but Trump wants to deploy it against, little old ladies chanting "Free DC, Free Palestine, Trump's the Hitler of our time." And Ted Cruz wants to help him out by amending the RICO law to add, quote, rioting to the list of RICO predicate offenses. But, okay, this is a story about basketball. You remember basketball?
This is a song about basketball. Okay, there is another indictment beyond the poker cheating. It also involves the former ball player, Damon Jones, as well as Sugar Shane Hennon and Eric Earnest from the poker scam. And this one also involves said point guard from the Miami Heat, the aforementioned Scary Terry Rozier, and it involves the Supreme Court.
So this one I can handle because no sports in it. In 2018, the Supreme Court decided a case called Murphy v. NCAA that a federal law prohibiting states from legalizing gambling on professional sports violated the anti-commandeering doctrine. That's the legal principle that says the federal government can't tell state and local law enforcement what to do, which seems relevant right now since the Trump administration keeps trying to tell state and local law enforcement what to do with respect to everything, but most particularly immigration. But this is not a story about immigration. This is a story about basketball.
Right. The practical consequence of the Murphy decision is that the major professional sports leagues were then free to partner with online betting sites and casinos. If you've watched basketball, baseball, or football in the past 5 years, you've seen the ads for those sites. And what you do is you download the app, you put it on your phone, you connect it up to your bank account, deposit some money, and you can start betting on games while you're watching the games.
Oh, yeah. I think it's called Raft Rings. Maybe it's...
We do not need to give them free advertising. Yeah, exactly. But I want to talk about a specific modern function of those apps that changed the way sports wagering works that really drove this second indictment. Because if you're like me and you think about illegal sports gambling, you think about something like the Black Sox scandal of 1919.
Say it ain't so, Joe.
Right. But that's classic sports gambling, right? Gamblers paid off the best players on the Chicago White Sox to throw games. But the problem with fixing team sports is that, you as the corrupt player taking the money can suck and play to lose, but the players around you might accidentally win anyway.
Any ideas?
On how we can get worse? How about a series of fines for good play? Maybe a $30,000 bonus for the guy voted least valuable player.
But online gambling sites, today let you bet on way more than just the outcome of a game. In fact, during COVID, when there were not professional sports because people couldn't be in the same area together, you could bet on things like who was going to go home on this week's episode of Top Chef.
Did you people not have wine?
I mean, that's how you get through an episode of Top Chef. Anyway, for purposes of this indictment, you can also make on these gambling apps what are called prop bets on individual player outcomes. So if you have a point guard, let's say, that averages 20 points per game, then the sites will let you wager on whether he's going to get around 20 points in that night's game. You can take the over, that he'll get more, or the under, that he'll get fewer. Sportsbooks make their money by setting that line correctly so that about half of the people betting take the over, about half take the under, those payouts cancel each other out, and the house gets to keep the vig. In basketball, you can't really control whether your team wins or loses, but you can control whether you play or not by, say, faking an injury, and, you can't get your 20 points when you're sitting on the bench. Enter Scary Terry Rozier, who, as of March 23rd, 2023, was averaging 21 points per game. He is alleged to have told one of the gangsters to bet the under on his prop bets for that day's game, and then he played just 9.5 minutes before taking himself out with an injury after scoring just 5 points. Okay, so that's Rozier. Damon Jones's connection here is that he was an unofficial assistant coach for LeBron James. So he's in the Lakers locker room. He's not playing, but he would know when LeBron James was listed as healthy on the report to the media, but was actually hurt and was not going to play. So paragraph 55 of the second indictment says that Jones texted one of the gangsters and said, "Get a big bet on Milwaukee tonight. Before the information is out, LeBron is out. But," and then adds, "bet enough so D. Jones can eat too. Now!" and one more little sports betting wrinkle. These online sites make somewhere around 3/4 of their total revenues on what are called parlay bets. That's when you bet on a string of occurrences, and they all have to come through in order for you to win. So you might bet on the Lakers to lose, and LeBron James to score fewer than 20 points, and Rozier to score fewer than 15 points, and Rozier to have fewer than 3 assists, and so on. And you get to customize all of those conditions of the parlay. But each and every one has to hit for you to get paid out. Now, the reason why parlays are popular is that when you just bet the win line or you bet the over or the under on a regular prop bet, the payout is typically 50-50, right? You wager $10, you either lose your money if you lose, or you get $20 back if you hit. But if you hit on, let's say, 11 legs of a complicated parlay, you might win hundreds or thousands of dollars on your $10 bet. So it seems like it's more fun. Each time you add a condition, the payoff increases. The odds of you losing increase more, which is why these are really profitable for the gambling companies and not for you as a bettor. But you can see how having inside information would let you leverage higher odds on these parlays.
Yeah, to me, the funny part was that Kash Patel, the current FBI director, came out there and played it off like it was just the Trump administration that did this. Like the investigation did start in a Trump administration because it started back in 2019, but it didn't, there's a lot of years in the middle there where it was not Trump. But yeah. That's our Kash. Okay. This indictment is 2 counts, none of which is RICO. It's conspiracy to commit wire fraud. That's placing the bets with insider information on the sportsbooks app. And there's money laundering because it's the mafia.
Yep.
We will keep watching. And right now, we're going to take another ad break. And we're back. Okay, let's talk about Donald Trump's effort to send troops to invade Democratic cities. We're still waiting to hear from the Supreme Court about the deployment in Chicago. Remember, the trial judge there said there was no rebellion or inability to execute the laws, and so there was no reason to summon the National Guard. And the Seventh Circuit agreed. The Trump administration has appealed. I suspect we will hear tomorrow from the Supreme Court, since they like to Friday news dump stuff as much as they can, especially when it is bad. But in the meantime,
calling balls and strikes. Sorry.
But in the meantime, a bunch of cases are percolating through the lower courts, particularly in the Ninth Circuit, which sits over both California and Oregon. On Wednesday, the Ninth Circuit refused to reconsider a panel opinion in Newsom v. Trump. Newsom v. Trump is the challenge by the state of California to Trump's deployment of the National Guard in the greater Los Angeles area. This is the first of 3 motions for reconsideration where judges on the court have requested that the larger panel, like I think there's 23 judges on the Ninth Circuit.
29, yeah.
29, right, and maybe 23 senior status judges. That a larger panel review the decision made by the 3-judge panel. Now, it's not a great decision, right, because this means that the bad decision by the conservative panel that had 2 Trump appointees is going to stand. That the court said the minor rioting in Los Angeles was enough to allow Trump to deploy the National Guard. But in and of itself, it doesn't make anything worse. And waiting in the queue is the Ninth Circuit's more recent and worse decision in Oregon v. Trump. That was another 2 Trump appointees panel. And Judge Graber, who was I think she's a Clinton appointee in the minority, implored her colleagues on the wider Ninth Circuit to act swiftly to vacate the majority's order before the illegal deployment of troops to Oregon can occur. And for all of us, speaking to you and me and everyone else, to retain our faith in our judicial system for just a little bit longer. And I will say my faith continues to be tested by the wider Ninth Circuit refusing to revisit the original Newsom v. Trump order.
I agree with that. So let's situate what the Ninth Circuit did yesterday in context. The original Newsom v. Trump stay order, that was the panel that created the highly deferential standard, right? That said courts can look to see if there's really an invasion or an insurrection. But if the president just says that he's unable to execute the laws, all the courts can do is ask whether that determination, and here I'm going to use the language from the panel opinion, reflects a colorable assessment of the facts and law within a range of honest judgment. And in practical terms, that means that if there's any evidence of interference that, and again, to quote from the panel's opinion, significantly impedes the ability of federal officers to execute the laws, then the court must say, yep, you know what, Mr. President, this is a reasonable justification. You properly invoke 12406, and you can federalize the National Guard. And that's not what the law says.
Yeah, and specifically in this case, the facts on the ground don't really reflect anything like rebellion. You know, the Seventh Circuit has adopted the same standard and said the facts on the ground in Chicago did not accord with Trump's, claim that he was unable to execute the laws or that there was rebellion. So we don't know on what basis one of the judges in the Ninth Circuit said, let's rehear this en banc, right? Maybe they wanted to accept the standard, but not the fact-finding, which was basically fact-free fact-finding by the Ninth Circuit panel. We don't know why one judge asked to rehear it en banc. And as you said, there are 29 active judges, 23 more on senior status. But they got fully briefed. And yesterday, the full Ninth Circuit voted against reconsidering the case en banc, meaning that the bad panel decision allowing Trump to point to a tiny moment of violence as justification to deploy the National Guard is going to stand.
Yeah. 3 quick points. First, this was a stay order. So that was emergency relief that was granted on the Ninth Circuit's equivalent of the Supreme Court shadow docket, right? So it's not binding precedent, but it has been cited by every other court that is looking at Trump federalizing the National Guard and sending in the troops. Second, you've been calling this the bad panel, and it is. We've been calling it a conservative panel, and it is. I think it is worth pointing out that the Ninth Circuit is not as liberal as its reputation and as conservatives like to complain about.
Certainly not after the first Trump term, it isn't, no.
Right. Yeah, of those 29 active judges, 13 are Republican appointees, 10 are Trump appointees. So what that means when you do the math is that if you lose just 2 Democratic votes and all of the Republicans hang together, then you lose 15-14. And third, We've already lost one Democratic vote. That's Judge Jennifer Sung. She was on the original panel that issued the stay order that we've been talking about. This is a little weedsy, but Liz, just bear with me for a second. That original stay order was a per curiam opinion. We've talked about this before. Per curiam means that it's unsigned. You don't know who wrote it. Now, when the U.S. Supreme Court issues a per curiam opinion, we often don't know what the vote is unless the justices write separately in concurrence or dissent. Now, a lot of the times that happens, but sometimes you'll have no published dissent, even though the vote wasn't unanimous. And I thought that might have happened here, right? That Judge Sung might have dissented from the vote, but just not penned a separate dissent. But a former Ninth Circuit clerk and two other California practitioners reached out to me on social media and said the standard practice in the Ninth Circuit is to publish a dissent if you're on a 3-judge panel that issues a per curiam opinion. So the fact that Sung did not pen a dissent should be taken as a sign that she agrees with her colleagues, which is really disheartening.
Oh, absolutely. So the decision to let the panel stand was met by this dissent, well, with an asterisk, from senior judge Marcia Barzon, one of Bill Clinton's last appointees to the court back in 2000. And the asterisk is because senior judges are not allowed to actually vote on the motion for reconsideration en banc, so technically styled as a statement regarding the denial.
Yeah, and we're not going to get too into the weeds of the merits, but I just have to say from a legal standpoint, this dissent is 100% correct on the law, right? As a matter of statutory construction, history, tradition, public policy, the president is not entitled to alternative facts to just declare an emergency and send in the military. I think the strongest argument that the dissent makes is that the prior statute, the Militia Act of 1795, used the language, whenever it shall become impracticable in the judgment of the President of the United States to enforce the laws of the United States, then he can call forth the militia of any or all the states of the Union. And then in 1903, Congress changed that law. They deleted whenever the president determines, and they replaced it with whenever, which seems to suggest we no longer look to the president's determination. They deleted impractical and they replaced it with unable. And as Judge Barzon notes, when Congress said unable, it meant unable, not impracticable or, these are her words, some other more weaselly standard.
Right. As a lot of the judges have noted when they've adjudicated this at the trial court level, Trump is saying, well, we had to allocate a lot of troops to do it, or we've had to do it, or there's been minor protests, and so we have to, allocate more resources, and that is being unable to execute the laws. And that's not what it says, right? It may be harder to execute the laws, but that doesn't mean you're unable. Right. So Barzon's dissent was joined by a bunch of Democratic appointees and no Republicans, which is very ominous. That seems to be a pretty strong endorsement of this president gets to determine a reality on the ground theory. Yeah. And there were 9 active Democratic appointees who did not join the dissent, which is also really ominous.
Yeah. So again, to go back to that math, one of those 9 Democratic appointees who did not join in the dissent was Judge Sung, whom we have talked about. Not surprising that she'd be a no vote on a motion to reconsider the order she herself joined. That may be a strong indication that she's a no vote on reconsideration in Oregon v. Trump, or it may not. We don't know. She may see a difference between the California case and the Oregon case. If she's a no vote, though, then each and every one of those remaining 8 Democratic appointees on the court would have to flip in order to rehear that decision en banc. And this seems like an uphill climb. But I guess if I wanted to offer some encouragement, it would be this. The Ninth Circuit is right now hearing expedited briefing on a motion for reconsideration en banc in the Oregon case. The Supreme Court is getting expedited briefing on Chicago, Illinois from the Seventh Circuit. And so maybe some of those 9 Democratic appointees who did not join in the dissent in this opinion are being pragmatic, right? Like maybe their thought process is, why should I go through the rigmarole of having an en banc rehearing on troops that are no longer on the streets in Los Angeles? That is the hope that Judge Barzon expresses at the end of her dissent. She says maybe her colleagues are keeping their powder dry for Oregon. Here's what she said. Hearing a case concerning a stay motion en banc is assuredly unusual. It may well be that those active judges who did not vote to hear this case en banc are now awaiting the merits opinion in this case and perhaps in Oregon v. Trump before deciding whether this panel's ruling is seriously wrong in its legal precepts and so merits an en banc review. But I continue to think that the president's disregard for this country's deep-seated commitments to the principle that armed forces must not be used as civil law enforcers, except where there is no alternative, should have been headed off now, not later. The panel opinion on the stay motion should have been reconsidered en banc.
Yeah, I think the whole thing is very ominous, and I am very concerned about what's going to happen tomorrow with the Supreme Court.
Yeah,
okay.
Me too.
We're going to take another quick ad break, and we will be back. And we're back. On Tuesday, the New York Times reported that the U.S. government is going to give Donald Trump $230 million to compensate him for the grievous harm done to him in the Russia investigation and the stolen documents case.
Yeah, I liked your headline for our blog, Liz. It's like Trump got tired of getting bribed in 50 other ways. It's no fun to have Binance park $2 billion in Trump's stable coins so that his company can get the interest float and then Trump pardons the CEO, which he did today, by the way, in case you guys missed that. Trump wants cash in hand, and since his cronies are in charge of the Justice Department, he gonna get it.
Yeah, it's almost like breaking down the law on this one is kind of beside the point, right? The law is secondary to the naked corruption, but law is our job. And to be fair, you really do need to understand the legal standard here to appreciate just how vile this payoff is. So the law in question is the Federal Tort Claims Act, or FTCA. FATSA is generally how people it's called, which is just kind of a bit on the nose. FATSA.
Yeah, tune in Monday for our discussion of the Kang-Coles Act.
Heyo. So FATSA is based on the premise that you cannot sue the sovereign unless he gives you permission. That's the doctrine of sovereign immunity. There are various exceptions, most of which have to do with property damage, the mailman hits your car, or physical harms, like medical malpractice at a VA hospital. But generally speaking, it is very hard to recover for torts committed against you by government agents. That's why you see ICE committing tort after tort against American citizens and everyone else, because the government isn't all that worried about getting sued, because see Rule 1, it's virtually impossible to recover against the government, or very hard anyway.
Right. So the procedure for making a claim under the Federal Tort Claims Act is that you file Standard Form 95 with the federal agency that you allege harmed you, and then the agency has 6 months to consider that claim. After that, you have 6 months in order to decide whether to sue. According to the New York Times, Donald Trump filed a Standard Form 95 in 2023 for the Russia investigation. We have not seen that document. We do know that he filed another SF-95 in August of 2024 for the documents case. The Times published that one, and it was preposterous.
Yeah, it's funny. At the time, one of Trump's gooniest lawyers, Daniel Epstein, announced on Fox Business in August of 2024 that he was filing this. Actually, what he said was he was suing the government, but what he meant was he was filing this SF-95. He did not post it online for us to read, and now I know why. This document is defective in every way. To start with, it alleges abuse of process and malicious prosecution, which fall under the intentional tort exception to FATSA.
Yeah, well, sort of, but mostly not, right? Like the intentional tort exception is more or less swallowed by something called the discretionary function exception, or DFE, which says that the government is not liable for any claim based on the exercise or performance or the failure to exercise or perform a discretionary function or duty on the part of a federal agency or employee of the government, whether or not the discretion involved be abused. So, In English, that means if a tort involves an official's judgment call, something committed to, say, prosecutorial discretion, it's off the table as a viable claim. You cannot recover under the FTCA. And what that means is, functionally, no one can recover against a prosecutor for prosecutorial misconduct. There is actually Supreme Court case law on this, which led to something called the Berkowitz-Gaubert test. So, the discretionary function exception, one, the acts alleged to be negligent must be discretionary in that they involve an element of judgment or choice and are not compelled by statute or regulation. And two, that judgment or choice in question must be grounded in considerations of public policy or susceptible to policy analysis.
Yeah, I do think we're actually going to be hearing about this discretionary function exception a lot because the government is committing so damn many torts that there are going to be a lot of lawsuits challenging this. But for the purposes of Trump's claim, I almost think we don't need to get too deep into it, right? These claims for compensation are defective in all ways, right? The Russia claims, whatever they might be, are long past the statute of limitations, which as you said, the government has 6 months after you make your claim of injury to either say yes or no, they aren't going to pay you. If they say no or they don't answer you, you have 6 months to file a lawsuit to get your recovery. If he filed in 2023, we are long past when it was too late. And with respect to the stolen documents case, to prove malicious prosecution, you have to demonstrate that there was no probable cause. I mean, there are 4 factors, but one of them is you have to, prove that there was no probable cause in your case. And here you have multiple warrants signed off on by judges, multiple grand juries voting to indict. And by the by, to win a malicious prosecution case, you have to prove that you were the winning party. And Trump didn't win the documents case, right? He wasn't acquitted. That case got dismissed because Judge Eileen Cannon discovered that special counsels are unlegal. It's not a win, and it, doesn't negate probable cause. And damn it, now I'm treating this like it's real law, which it's definitely not.
No, clearly not. This is the Justice Department deciding to hand the president hundreds of millions of dollars. And as long as we're pretending that this is real law, the Federal Tort Claims Act clearly and explicitly prohibits recovery of punitive damages. And $200 million of that $230 million is supposed to be for punitive damages, right? And lest we forget, the decision to sign off on this settlement goes to the Deputy Attorney General and the Associate Attorney General. That would be Todd Blanche, who represented Trump in the documents case, and Stan Woodward, who represented Trump's henchman Walt Nauta in the documents case. Naked corruption does not go far enough to describe this. And, as with so much of Trump's second term, this is directly traceable to Chief Justice John Roberts and the Supreme Court's conservatives saying that nothing Trump did in office was illegal.
Yeah, well, funny enough, that's what Daniel Epstein said. He said that Attorney General Garland, as a former judge, should have known that the Supreme Court was going to say the president can do crimes. And ipso facto, there you have your evidence of malicious prosecution. Thanks, Chief Justice Roberts. All right, that is going to do it for us today. If you are a subscriber, stick around. We're going to talk about one of Trump's most bumptious lawsuits and how a reporter is trying to beat him at his own game. If not, we will see you back here on Monday with more written content and on Tuesday with another show. And we'd love you to become a subscriber at patreon.com/lawandchaospod or lawandchaospod.com. And if not, we still love you anyway. And if you wanted to give us a 5-star review on your podcast platform of choice, we would not be mad about it. Have a great weekend. We will see you guys soon.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Up to Media, LLC, all rights reserved.